Christy Madrano on behalf of JP Morgan Chase Bank.
And anyone here on behalf of Mr. Cisneros? I don't see anyone. Ms. Medrano, you may proceed on your default. Well, let me ask you this. As I pull your case up in Odyssey, when did we send notice regarding this hearing to defendant?
Looks like this was, the order setting hearing was signed on February 15th.
Okay. And so, okay, so no, actually on the default, I'm going to reset this default for 30 days. What I would like is, so that'll put us at April 5th. April 5th, okay. And with that date, it'll be at 10:30 a.m. Please
Okay.
send notice of the hearing in whatever manner you've, I guess, had any or the best success, and have that ready for the court for the next hearing, and then we can go forward on the default.
Okay, Your Honor, let me ask you one question. I had reached out. We still show an attorney, Richard Burton, on as opposing counsel. And I had reached out to them and spoke to Ben Hoover. I didn't talk to Mr. Burton himself, but I think Ben Hoover's another attorney. And they were trying to reach their client. So I think there is an opposing counsel on the case.
I don't show anyone in the history, under the parties here. I don't show an attorney. If there is one, and you've been communicating with them, maybe they need to be given the heads up about this. I don't reflect anything in my system about an attorney.
Okay.
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 All right. Thank you, Ms. Pedano. We'll see you back in April.
April 5th, 10:30 in the morning, we'll send notice of hearing to the defendant. And that's going to be on my motion for default, correct?
Yes, ma'am. Mm-hmm.
Thank you, Judge. May I be excused?
You may. Take care.
Thank you.
Okay. So there's Mr. Ramirez.
In cause number 2022 DCV 2001, the Nevares Law Firm PC versus Perseverance Group LLC and Jesse Ramirez. Announcement of counsel, please.
Yes, Michael Nevares for the plaintiff, Nevares Law Firm, PC.
Jesse Ramirez on behalf of myself.
Okay, we are scheduled today for both the default hearing, which I believe was a reset from about 2 weeks ago, and then we're also set for a scheduling status conference. I do want to ask though, and let me go back to my emails before we start with those things, is that I received or I was forwarded documents. I don't know if they were e-filed by Mr. Ramirez. Do you know where they e-filed, Mr. Ramirez?
Yes, ma'am. I e-filed them late yesterday afternoon.
And Mr. Nevares, let me go back and look at them. I'm just going to ask if you've received them or you were served with them.
Yes, Your Honor, I received them this morning. I believe they came in late yesterday, but I have looked at them.
Okay, so let me go back because I saw them this morning as well, and just want to see. Okay. So, Mr. Ramirez, I'll tell you right off the bat, this has been an ongoing issue that your individual appearance today is the only one that the court is recognizing. Okay, and so in terms of any type of appearance or any type of pleading that you have filed individually on behalf of the entity, the court is not acknowledging. You cannot represent that LLC. And so just to get that, because I think it's going to impact everything, meaning number one, Mr. Nevares is going to ask to proceed on his default today. It is asked to both parties. And so I am only considering your appearance on your own behalf individually. Now, in these documents is a request for continuance by Jesse Ramirez. What are you asking, Mr. Ramirez, on the motion for continuance? Mr. Ramirez, you're muted. Oh.
Yes, excuse me, Your Honor. Well, I think I had some help putting that together, and I think it's explained pretty well in the continuance. I guess it's to give you time to consider that motion that I did file as well yesterday.
So let me explain the
And-
process. Let me stop right there and explain the process a little bit. You have filed, or what I have in this email, Mr. Nevares, is a request for continuance of today's default hearing, and then a separate motion to dismiss. Motion to dismiss. Dismissal of claims against. And this is filed Jesse Ramirez. Okay, again, it's on. Okay, so a motion to dismiss the lawsuit. So how it works, Mr. Ramirez, is when you file something and you want a hearing on it, you need to request it. I mean, if you filed this, fine, great. It's not set for a hearing today. So you can request the court set it for a hearing, but that is not going to be heard today, period. Secondly, you again filed it on behalf of you and the corporation. And again, the court is not going to entertain anything that you file on behalf of the LLC. Okay, so the only thing we have set for today is the default hearing and any type of scheduling status. So on the motion for continuance, I need to know the basis for the continuance. I mean, you're telling me in this motion, the need for the continuance is to allow me time to consider the pending motion to dismiss. It's not set. I got it this morning, so. That's
Yes, Your Honor.
Mm-hmm.
Well, I think my concern is, and the motion does express that as well, is as pro se, I should say, I guess I have a legal right to represent myself, right? And I think you just explained that. But based on the motion that I'm basically asking for the entire case be dismissed based on the facts and the case law in the motion, which I'd like to give you time to consider. My concern is right now the business is not functioning. So I have tried to retain attorneys. It costs a lot of money and I have not been able to retain them up to this point. So my concern is if I don't have to retain them at all based on the motion and case law that I expressed in that motion that I did get a little bit of help with, then that would alleviate that concern for me. And I'd like to at least give you some time to consider that. I'm sorry, it was last second. I did try to retain an attorney, but it just couldn't get worked out financially in order to retain them within that 2-week period I was given. So that's where I stand. Really, as far as legal arguments are concerned, all I have is what's in the motions. And again, I'm not an attorney, but I do want to retain any pro se rights I do have as far as myself is concerned. But that's really it, Your Honor.
Mr. Nevares, I was just going back. Okay, so in terms of your request to continue the default hearing, that is denied. Okay, the motion for continuance there is denied. Mr. Nevares, so now we're back to the default hearing. Mr. Nevares, I just wanted to double check. Your motion for default only is with respect to the entity, is that right?
That's correct, Your Honor.
Okay, so you may proceed on your motion for default against Perseverance Group LLC.
Yes, Your Honor. Thank you. It should be indicated that the answer that was filed by Mr. Ramirez on behalf of Perseverance Group LLC was not filed by an attorney. And as Your Honor has explained, 2 previous hearings to Mr. Ramirez, he needs to be represented by an attorney for this court to consider the answer on behalf of the LLC as valid. At this point, his answer, Mr. Ramirez's answer on behalf of the LLC should not be considered as having been timely filed. In fact, it constitutes the unauthorized practice of law by Mr. Ramirez which is against the laws of the state of Texas. His motion for continuance that was filed this morning, along with his motion to dismiss, are also invalid as concerns the LLC. They also constitute an unauthorized practice of law by Mr. Ramirez. Mr. Ramirez has been, as I stated earlier, twice at 2 previous hearings been told that he needs to hire an attorney. He's failed to do so. We had this same battle at the bankruptcy court. So based on the failure of Perseverance Group LLC to file a valid answer signed by an attorney authorized to practice law in the state of Texas, I believe the default judgment should be issued because the answer that was filed by Mr. Ramirez on behalf of Perseverance is just simply not valid. I have nothing further, Your Honor.
Okay, what is, I'm going through the motion for default. And it's filed with a lot of the exhibits in different files. So that's why it's taking me a second to go back and forth. What is attached to the default motion to support your motion?
Well, if Your Honor gives me a few minutes, let me pull that out.
Yeah, the Odyssey access here, I can look at one attachment, and then when I get out of it, I have to go back and start from scratch. So it takes me just a little bit of time. I think I see one was the exhibit A was the return.
That's correct.
And this is the return on the LLC.
And then exhibit C is the certificate of last known address. Exhibit D is a plaintiff's service member's affidavit. Exhibit E is the affidavit for damages. Exhibit F is the affidavit to prove notice. And then,
Tell me, Mr. Nevarez, tell me a little bit about the damages.
Well, the damages all stem from a contract, a retainer agreement that was signed by Mr. Ramirez for me to represent the LLC in Chapter 11. I did so, and he put together a retainer and told me that we were going to form a reorganization plan. Mr. Ramirez failed to cooperate in us putting together a reorganization plan. It turns out that all he wanted to do was for me to get him released from his own personal liability, which occurred through the numerous agreements that I entered into on behalf of the LLC and Mr. Ramirez. So the damages are essentially all the attorney's fees and costs that were incurred over and above the retainer. It's basically a breach of contract, Your Honor. I did a lot of work and didn't receive compensation beyond the actual retainer.
Is there anything here regarding, or is it attached to the original petition? Anything regarding the what you charged?
Yes, Your Honor. There's the initial petition had attached a compilation of invoices and statements. They also contain the retainer agreement, and so yeah, they were attached to the original pleading, as well as my affidavit for suit on sworn account and account stated.
Okay, let me just go through these very quickly. Okay, and so the retainer agreement was signed by Representative Perseverance, that being Mr. Ramirez. Okay, yeah. Okay, and then the billing statements are. Okay, anything else, Mr. Nevares?
No, Your Honor, I think, everything's in there. The agreement is, Exhibit A. Exhibit B is the statement with all the invoices. And then, Exhibit C is my affidavit, verification for suit on sworn account.
Okay. Okay, good. That's all we exhibits. Okay. All right. If there's nothing else on the default, the court is going to take judicial notice of the entirety of the file, including those exhibits not only attached to the motion for default, but also the exhibits attached to the original petition. Let me go back. Court is also then going to grant default judgment in the amount requested against defendant Perseverance Group LLC. I do believe I saw a proposed order here. Let me see. Okay. There is a proposed order. So we'll get that filed. Mr. Ramirez, now that still leaves Mr. Nevares' claim against you individually. We are set for a scheduling conference today. We need to get this on some kind of trial track, if that's what you're going to be pursuing, Mr. Nevares.
Yes, Your Honor.
Okay, so we're going to do a year out. We're going to do January 12th, 2024. Mr. Ramirez, what that means is there is going to be a document that we are going to provide, the court is going to provide to you and Mr. Nevares. I have assigned a trial date for January of 2024 for any claims that remain against you individually. There are interim dates and deadlines that are included as part of that scheduling order. Once you confer, if you continue to represent yourself, once you confer with Mr. Nevares about a potential mediator and on the scheduling order itself, then I expect that each of you will sign off on it by agreement with the agreed to mediator and return it to the court. Once you've done that, we will have the slate of settings to handle your case. If you retain an attorney, then they need to file an entry of appearance, and your motion to dismiss, if you're requesting a hearing on that, because there still remains your portion of the motion to dismiss that is urged by you individually, we can go ahead and schedule that. I will schedule it 30 days out. So we're probably looking at April 5th at 10:30 a.m. In the interim, Mr. Ramirez, if you get an attorney, then they can advise you about anything that has transpired in the case thus far, but you will get your hearing on your motion to dismiss, okay?
Thank you, Your Honor.
All right, and on the motion to dismiss, unless I hear otherwise from you all in any other settings, we'll do everything via Zoom, okay?
Very well, yeah.
All right, thank you. I've got your proposed default, Mr. Nevada, so it'll get filed.
All right, thank you, Your Honor. Are we dismissed?
You are. Thank you very
Thank
much.
you.